Friends, namaste and welcome to another episode of Legal Words of Wisdom, Nyay Gyan Ganga, which we host every Saturday at 8 p.m. Indian Standard Time on our Virat Hindustan Sangam social media channels. And we are back today again with Dr. Subramanian Swamy and Barrister Dr. Venkat Iyer for another episode to understand law and know more about the various aspects of law. As you know, Dr. Venkat Iyer is a barrister, mediator, and legal academic based in United Kingdoms. He is also an advocate admitted to the Indian bar where he practiced between 1981 and 1990. He has been associated with our legal Gyan Ganga, as you know, and this is the fourth episode. He, along with Dr. Swamy, will be discussing various issues concerning the relevance of law for the common man. So we welcome you all to this show, which, as you know, is being across the globe and nearly 125 countries viewers watch it live. So I thank Dr. Venkat Iyer and Dr. Swamy for giving their valuable time to educate and I would say make the viewers and Virat Hindustan Sangam volunteers aware of what's happening around us on the legal front. So without much, I thank my co-host Ramesh Swamy and the technical team led by Ashish Shetty, Tejas from Pune, Swaminathan from Chennai, Ishwar Iyer from Navi Mumbai, Rakesh Gadgi from Bangalore, and Vishal Mehta from Mumbai for their support to put this program together. So with these words, it's over to Dr. Swamy for his opening remarks and then Venkat Iyer. Over to Dr. Swamy.
Thank you very much. It's a great pleasure to again welcome Dr. Venkat Iyer and on a subject which many people are interested in India because they really don't know what their rights are and what kind of rights they have and how they can enforce them and how they can sue people for violating their rights and so on. So many questions are there. Essentially, what Dr. Iyer, we would like you to expound on is first the kinds of rights. There are fundamental rights. There are inalienable rights like the Preamble in the Constitution. And then there are rights in procedure, such as in the Criminal Procedure Code or in the various sections of the Civil Procedure Code. So I think it needs a perspective. What are your rights? Sometimes people ask me simple questions like, can I be arrested by any policeman at any time? Or if I am called to appear in a police station without knowing for what, do I have to oblige? These basic kinds of questions. So on the general question of what rights you enjoy in a civilized society which has a constitution or at least the rule of law, and there are procedures laid down in writing which have been adopted by Parliament or Senate or whatever, the US Congress, etc. So could you give us a perspective, therefore, Dr. Venkat Iyer, on the rights that human beings in India enjoy and how to enforce them and how to safeguard them?
Thank you. Before I begin to talk about rights, I want to deal with a couple of matters which I referred to in my previous lectures, including last week's, but could not talk about them at any length. I don't intend to take more than 5 minutes to address those matters. The first issue I want to deal with is the role of tribunals in the Indian justice system. As I indicated in my second lecture, tribunals are bodies which dispense justice, but they are slightly different from courts in that they are less formal and they involve a degree of specialization which courts don't. In India, there are tribunals dealing with various subjects such as employment disputes, motor accident claims, telecom disputes, company law matters, etc. The first thing to note about many of these tribunals is that they have exclusive jurisdiction, which means that if you have a grievance that you want to litigate, you cannot take it to a court, but you must go to a nominated tribunal instead. For example, if you're a government employee and you've been unlawfully treated at your workplace, then you'll have to approach the Central Administrative Tribunal and not a court of law. Unlike the courts, the tribunals consist of not only legally qualified judges but lay persons, which has caused some concern, especially given that the lay judges are usually serving or retired bureaucrats. Also, the tribunals have been given the same status as high courts, which is seen as diluting the stature of the senior judiciary. There's been a lot of misgivings about what may be called the tribunalization of justice, mainly on the grounds that it represents not only an assault on the independence of the judiciary, but a breach of the separation of powers principle, both of which are considered to be part of the basic structure of the Indian Constitution. The mischief started in 1976 when, during the bogus emergency declared by Indira Gandhi, a whole new chapter was added to the Constitution under the notorious 42nd Amendment to replace courts with tribunals in certain areas. This was done ostensibly to speed up justice, but many people believe that the real purpose was to curb the powers of the judges who were seen as willing to stand up against injustice and tyranny. Unfortunately, even after the emergency ended and democratic rule was restored, the new government failed to roll back all the changes that were brought about by the 42nd Amendment. Subsequent attempts to challenge those changes in the courts were only partially successful. And so the tribunals have come to stay, whether you like them or not. A particularly worrying feature of the tribunal system is that they are seen as encouraging undesirable behavior, and I'm deliberately using a mild term, among many senior judges who aspire to become chairman of some of the tribunals after their retirement from the courts. This is because most of those leading the tribunals are chosen from retired senior judges. For lack of time, I will, I think, leave that issue there. Related to the tribunals is the question of what status bodies like panchayats and lok adalats enjoy under the law, or more specifically, whether their rulings are legally enforceable. A question which was raised by Ramesh during the last episode. As I indicated then, the position with panchayat rulings is that they are on very shaky legal ground. The Supreme Court has said pretty much in clear terms that that is so. For example, there was a case decided in 2010 in which a panchayat purportedly passed a decree of divorce, and that was set aside immediately on the ground that the panchayat lacked jurisdiction to pass legally enforceable orders. The position with lok adalats, however, is slightly different. A lok adalat is like a court conducted with a degree of formality by the National Legal Services Authority under a 1987 Act, and its rulings are deemed to be decrees of a civil court. They are final and binding on all parties as long as the parties have agreed to come before the court voluntarily. This is quite important. If they don't agree, they cannot be compelled, and their cases will be heard by a regular court. Incidentally, two types of case that cannot be dealt with by a lok adalat are, first of all, criminal cases which are not compoundable, and secondly, proceedings for divorce. In dealing with these bodies, I have, mainly for reasons of time, simplified the position quite a bit and just given you an overview. If one were to go deeper into these matters, one would discover that there are very significant complexities and a fair bit also of ambiguity. I now want to turn to the main topic of today, which is rights and how the law deals with them. It is a topic which is huge, complex, and difficult to understand. First of all, there are issues of terminology. What are rights? How are they different from, say, liberties or freedoms or prerogatives or privileges or entitlements? Remember that all those terms are used in legal documents, including constitutions. Again, partly for reasons of time, and partly because this lecture series is intended to simplify the law for common people, I will resist the temptation to embark on a philosophical or a semantic inquiry into terminology. Fascinating though such an exercise would be for those who enjoy such things. I will also resist the temptation to talk about another huge aspect of this topic, namely the politics and the controversies that have come up when you have a discussion with anything associated with the world of human rights. There is, however, one point I do wish to make without going too deep into it, and that is the intimate connection between rights and duties. It is my firm belief that increasing detachment between rights and duties, or obligations as they're sometimes called, is the root cause of many frictions in society. And it has led to a lot of avoidable problems, especially in the West. For our purposes, a right can be understood simply as a legal concept which indicates something that is allowed of a person or given to a person according to some organized system and which is based on accepted principles of freedom or entitlement. Not surprisingly, there are different types of rights which people enjoy. I would name three in particular which are relevant to our discussion: constitutional rights, statutory rights, and natural rights. Now, within constitutional rights, it is possible to talk about fundamental rights and ordinary constitutional rights. I'm going to steer clear of the topic of natural rights, though that is not unimportant. Indeed, it featured quite heavily in one of the most important cases heard by the Indian Supreme Court, namely the habeas corpus case in 1976. The difficulty with talking about natural rights is that in reaching consensus, you'd enter into all kinds of difficulties, even at the best of times, because many people believe that such rights don't exist. So, if we revert to the other types of rights and take constitutional rights first, we need to recognize that the Indian Constitution confers many rights which are spread across that long document. Most of the time, when people talk about constitutional rights, they think of Part 3 or Chapter 3, as it's called, of the Constitution, which is headed Fundamental Rights. But actually, there are many other rights which are to be found directly or indirectly outside Part 3, but still within the Constitution. For example, the right to property, the right to vote, the right to citizenship, the right not to be subjected to taxes without the authority of law, the right to carry on trade, commerce, etc., within the country, and so on and so forth. A very important general point which needs to be made at the outset is that no right is absolute. And I mean this without qualification. You may ask, but what about the right to life? Is that not absolute? I have to disappoint you by saying, no, the right to life is not absolute. And why do I say this? I say this because it is perfectly legal to take away someone's life in certain circumstances.
Yeah.
Abortion, for example, is legal when carried out within 20 weeks of pregnancy. The death penalty is legal for certain offenses. Killing someone in self defense is legal, and so on. Therefore, if you begin to think about it carefully, every right is qualified or conditional. And I
Yes.
shall return to this theme shortly. Going back to the Constitution, how are fundamental rights different from other constitutional rights? The answer lies in their mode of enforcement. The Indian Constitution makes special provision for the enforcement of fundamental rights. It does so by stating that anyone who wishes to assert their fundamental rights can approach the Supreme Court directly under Article 32 of the Constitution. And that right of approaching the Supreme Court has itself been made a fundamental right. So, in a sense, a hierarchy of rights is created under which fundamental rights stand on a higher footing than other constitutional rights. But those constitutional rights also enjoy a high degree of protection because anyone who wants to enforce them can approach a high court, which is given the power to issue certain important remedies, including a range of writs under Article 226. Don't underestimate the importance of Articles 32 and 226 because without effective remedies, rights are of no use. There is an old principle of law which underlines this point, ubi jus ibi remedium, and this is always worth remembering. These are not, of course, the only remedies provided for by law. There are many other legal enactments which lay down remedies for particular situations. To give you an example, if you're trying to assert a property right, say in relation to land, there are certain orders that a civil court can pass under the Transfer of Property Act. Such rights are called statutory rights. The difference between a constitutional right and a mere property right was to some extent involved in the Ayodhya case, and Swamy has frequently referred to it in his various public lectures. Now, what about the fundamental rights themselves? I want to spend a few minutes on this matter. As I told you earlier, these are rights contained in Part 3 of the Constitution, or Chapter 3 of the Constitution. They are grouped under a few headings. For example, the right to equality, the right to freedom, which is most frequently cited as part of the chapter on fundamental rights. Also, the right against exploitation, the right to freedom of religion, which is surprisingly given separate place, cultural and educational rights, and right to constitutional remedies. There was one other heading, namely the right to property, but that was deleted by the 44th Amendment in 1979, a point to which I shall return towards the end of this lecture. It is worth noting that while most of the fundamental rights are available to any person living in India, some are restricted to citizens alone, and this can be found in Article 19. There's also a provision at the start of Part 3 which says that any law that was enforced before independence and which is inconsistent with the provisions of Part 3 shall be void to the extent of the inconsistency. This means, for example, that all colonial laws that do not conform to the fundamental rights have no legal effect since the coming into force of the Constitution. And very wisely, the word law was made to include all types of law, including delegated legislation, ordinances, customary law, etc. Part 3 also brought in a prohibition on what can, in shorthand, be called hostile discrimination, that is, irrational discrimination. The general principle is that everyone is equal before the law and that they enjoy equal protection of the laws. The principle of equality may sound simple, but it is quite difficult to deal with it in law. The reason is that there are situations in every society in which discrimination may sometimes be justified. To take an oversimplified example, if there is a law which says that no disabled person shall be discriminated against, and if a blind person is turned away when he applies for let's say, a car driver's job in a government department, can that person seek damages against the department on the grounds that he was discriminated against? The answer is, of course, not. The way that the law tries to deal with such situations is by accepting a principle of reasonable classification, under which the varying needs of different classes of people can invite differential treatment. But to ensure that this concession is not abused, the law puts some controls over it. First of all, the classification must not be arbitrary or fanciful, and it must rest on objectively verifiable differences. Secondly, any law that is passed to take the differences into account must demonstrate a clear connection between the classification and the objective that is sought to be achieved. For example, if a law allows drivers of emergency vehicles like fire engines to break speed limits on the roads in certain circumstances, but the same law does not allow other drivers to do so, then such discrimination can be justified on the grounds that fire engines need to reach their destinations quicker than other vehicles which are driven for less important purposes. There are quite a few other challenges with the concept of equality. First of all, one needs to make a distinction between equality of opportunity and equality of outcome. Most people will agree that equality of opportunity is a good thing, that everyone should have the opportunity to seek something or to compete for something, commensurate, of course, with their abilities. But equality of outcome is more problematic because even if you give two people the same opportunities, they may end up performing differently. One may have more talent, energy, or enthusiasm, or greater motivation, or a more enterprising attitude than the other. The
Right.
other may be lazy, profligate, stupid, or lacking in a work ethic. Now, should you be surprised if the former ends up in a better or more advantageous position than the latter? Most people will say not. But this fact is not always understood or accepted by many campaigners for equality. It is, as you'll see, a topic which has huge potential for debate and for controversy. But I will have to leave it there for reasons of time. Another challenge in the area of equality is that it has the potential to clash with freedom. There are many things people like to do and have done for generations, but which they are now forbidden on grounds of equality. And this has caused severe tensions. In Western countries, a common example is the status of single sex institutions, whether it's a men only club or a women only college. An Indian example with which you're all familiar is what happened in the Sabrimala case.
Yeah.
Um, Here, as you know, the Supreme Court in 2018 ruled that the age old prohibition on the entry of 10 to 50-year-old women violated the right to equality and must therefore end. This can be seen as a clash of freedoms. In this case, the clash between the right to equality and the right to freedom of religion. The larger lesson that can be drawn from such examples is that rights can and do conflict with each other, and there will have to be ways found to deal with such conflicts. Which then brings me to another important aspect of rights, and something I've already referred to, albeit in passing, namely that no right is absolute. The Indian Constitution recognizes this very fundamental fact and provides what I would call a sensible way of dealing with it. Very generally, it's based on the harm principle, which is essentially that a right can only be exercised legally if it does not cause harm to others. A colloquial way in which I can put this is to say that the freedom of my fist ends where your nose begins. What this means, of course, is that I can swing my fist as much as I like, provided I don't bring it in contact with your nose. The legal formulation is, of course, slightly more sophisticated than that, and it runs as follows. First of all, it would be entirely acceptable for the state to impose restrictions on rights for the larger good of society. But those restrictions must, first of all, be reasonable, which
Yeah.
means that any unreasonable restrictions will be invalid. Now, there can be huge arguments about what is reasonable and what is not, which is inevitable. And the final arbiter for such arguments will have to be a neutral, unbiased entity in the form of a judge. As you can imagine, disputes about the reasonableness of particular restrictions are not easy to resolve, and they occupy a large amount of the time of judges. But there is, alas, no better way of dealing with this problem. And the good news is that, by and large, judges are able to arrive at sensible solutions most of the time. A second condition for any restriction imposed on a right to be accepted is that there must be legal authority for that restriction. This means, in practice, that the restriction should be contained in a law, whether it is law passed by parliament or a state legislature or law laid down by a court, that is, common law. And that law should, of course, not be unconstitutional or otherwise defective. What this means is that there is no room for arbitrary exercise of power or high handedness by anyone, regardless of what position they hold.
Yeah.
To take an example, if a police commissioner tries to reroute a religious procession, and for that purpose he uses a law which gives him the power to divert funeral processions and funeral processions only, his action can be challenged on the grounds that the law being used does not authorize him to divert a religious procession. He cannot argue that a religious procession is similar to a funeral procession. Now, it is possible that the same law has another clause which allows the commissioner to divert all other processions. But that clause may require the approval of a higher authority, for example, the Inspector General of Police. Now, what the commissioner has done in our example is to bypass the need for such approval, and he has taken a shortcut. Such actions are illegal. Thirdly, any restriction imposed on a right has to fall within one or more of the heads listed in the Constitution. These include the interests of the sovereignty and territorial integrity of India, the security of the state, which is usually referred to as national security, public order, friendly relations with foreign states, and also decency or morality. Other heads under which restrictions may be imposed, depending on the right involved, are in relation to contempt of court, defamation, or incitement to an offense. These are restrictions when it comes to freedom of expression, or the imposition of technical or professional qualifications when it comes to the right to practice any profession or to carry on any occupation, trade, or business. The state is also allowed to impose restrictions by way of a requirement to obtain licenses or permissions when it comes to the right to set up a trade, business, industry, or service. Exceptionally, the state can even impose restrictions in the interests of the general public or in the interests of a scheduled tribe. And that, of course, is when it comes to the right to move freely throughout the territory of India or to reside and settle in any part of the country. Clearly, the phrase in the interest of the general public is a bit too wide and has the potential to cause mischief. Not surprisingly, these provisions have been deployed by the government time and time again under various circumstances. Even less surprisingly, they have generated an enormous amount of case law because those affected by the restrictions imposed on their rights have often gone to court. The case law in this area is, I would say, as fascinating as it is bewildering. I do not, of course, have the time to discuss it, but I want you to know that a lot of extremely ingenious arguments have been used in such cases. To understand how the system operates, let's consider the right to move freely throughout the territory of India. This right can be restricted, as I've just said, in the interests of the general public. And in the context of the current pandemic, people can be stopped from moving freely within various parts of India. But for any such restriction to be valid, the government must pass a law, say like a movement control order, which should state clearly what its parameters are and which should also be reasonable. The idea of reasonableness includes proportionality. So, if the government passes a law which imposes a blanket and sweeping ban on any movement, including, say, the movement of essential workers, that law will not be considered to be reasonable and it will therefore be struck down by the court. All three conditions will therefore have to be satisfied to make the restrictions legal. One other thing which is worth noting is that the list of fundamental rights has been expanded over the years, mostly through judicial interpretation. For example, the right to life, guaranteed in Article 21 of the Constitution, has been said to include certain implied or derived rights, such as the right to live with human dignity and the right to privacy. Parliament itself has added a new right, the right to education for all children between the ages of 6 and 14, through a constitutional amendment which was brought in I think, 2002. A question that is worth asking in this context is, are there any dangers to increasing the list of legally enforceable rights without paying too much attention to whether they can be meaningfully enforced? This question is particularly relevant to what may be called social, economic, or cultural rights, which I've not been able to discuss at all. I want you to consider that question, especially in relation to the point I made earlier about the intimate connection between rights and responsibilities. I would like to end this talk by drawing your attention to the fact that an important fundamental right was actually removed from the Constitution as originally enacted, and that was the right to property, which had originally been part of Article 19. The ostensible reason given for the deletion, which happened during the controversial state of emergency declared in 1975, was that property rights stood in the way of economic reform, an argument which became the subject of intense and, I would say, fractious debate for decades, and which is worth reading about even today. In the remaining half a minute or so available to me now, I want to draw your attention to the fact that although a new democratic government came into power after the emergency ended in 1977, and that government had an opportunity to reverse the injustice of the deletion of the right to property, it chose not to do so. And that was a cause for much dissatisfaction among many people, especially those who supported the Janata Party. Now, what the government did instead was to create a new ordinary constitutional right in the form of Article 300 capital A, which simply said no person shall be deprived of his property save by the authority of law, or words to that effect. Perhaps Swamy can tell us why this happened, given that he was quite close to the Janata government and particularly close to the then Prime Minister, Morarji Desai. Now, that I think is as good a time as any for me to stop talking and to thank you for your patience. Goodbye.
Doc, one
Tell
second.
me, yeah.
Doctor, yeah. Oh. Please go ahead, Dr. Swamy.
Okay. No, Ramesh was
I
going to
had
say
a
something.
question essentially on the RTE.
Yeah.
The RTE though has got a lot of good things. I mean, basically the original RTE when was proposed was actually a very good boon for the poor people. I mean, getting a good education, but then there were exceptions being made, not for minority institutions, and it just has got into a thing when you have a right, and you say yes, there are reasonable exceptions, but that exceptions that they've given to minority institutions is what is not digestible. I think that is what has caused the controversy, not the RTE per se, but why only minority institutions. So, do you have any, the comments? Because since we're talking about rights, how can they create an exception just because you're a minority institution?
Well, that is because there is another clause in the Constitution which has been there for much longer than the newly inserted Article 21A, which guarantees autonomy to minority institutions. Now, that is actually an article which has generated so much case law that it'll probably require me 2 or 3 hours to even explain the extent of the litigation that is that
You,
there is under that. Now,
you mean Article 330?
no,
Article
no,
30?
actually, I can't immediately remember the number. It is 20 something in the
30, 30.
Constitution.
Anyway.
Yes, it could be 30. You're right, something like that. I don't have the copy of the Constitution here, but I personally was involved in a number of those cases in the time I was practicing in India. So what it means essentially is that the Constitution makers had given a degree of autonomy to minority institutions. That led to a number of difficulties because it was felt that the minority institutions, not all of them, but some of them, began to abuse that autonomy. So when that happened, then of course, as I said, there was a lot of litigation. Now, quite clearly, the reason why what is happening now has happened, I'm going back to Ramesh's question now, is that the minority institutions are going to resist because they'll say we have a prior constitutional right to autonomy, and why should we give that up? So that is a real problem. And in a way, Ramesh, you've raised an extremely important issue, more fundamental than just the right to education. It has to do with clash of rights. When you have a document like a constitution, you have to be very careful that you don't put in things that clash with each other. And so I would say that the amendment giving the right to education has not been properly thought about.
Well, it is Article 30. I'm
30.
just
Yeah.
30.
Thank you.
Shall I take over?
Yes, in fact,
sir.
I'd particularly like you to address this issue of the right to property.
Yeah, okay. I'll start with that, and then I have one other matter to add to your very interesting and comprehensive lecture today. What happened was this, that we were reversing these obnoxious, what was called the 42nd Amendment, the various sections, the various articles of the Constitution which were amended, and we were restoring the original position. At that time, the question of the right to property came. And I was a member of the select executive committee of the parliamentary party. Party itself had an organizational part of the party, also had a national executive, which was very large. But this was a elected one. All the MPs used to elect, and I got elected of all the things because Mr. Vajpayee wouldn't let me contest. So I contested independently and defeated his candidate, namely Advani, and became a member of the parliamentary party executive. In that, the question came up. Unfortunately, the socialists said, no, we can't remove this because our position will be weakened, and we'll walk out of the government, we'll walk out of the party if you do that. And Mr. Vajpayee also lent them support. So it became only Charan Singh and Morarji Desai and myself who were for the restoration of the fundamental right to property. That's how it stayed. And we had hoped for a better day, another occasion when we can do it, but that occasion never came. Now, the second thing is, there are two very important sections of the Constitution on rights, which you have not covered. So maybe you can cover it another occasion.
Yeah.
One is called the Preamble, which is considered part of the basic structure. So you'll have to also expound on the basic structure. What is the basic structure of the Constitution? When was it introduced and why? And in short, it was just to prevent another Mrs. Gandhi coming and amending the Constitution left, right, and center.
Yep.
So there are certain things you can't do. For instance, you can't pass a 2/3 majority in Parliament that Mrs. Gandhi has become the Queen of India. Because basic structure is democracy is part of the basic structure, and that cannot be amended under any circumstance. There's no scope for amending it. Similarly, fundamental rights cannot be amended. So all these were put into the basic structure. So the basic structure is something that people must learn and must know, number one. And in that is faith,
Yep.
which is what I used in the Ram temple. I said it is not only my fundamental right, but it is the part of the basic structure. And therefore it cannot even be amended. And my faith tells me that Ram was born at that particular place, which is what nobody else had argued till then. All these long litigations, all suit, my property, your property. It was, the whole thing was that, and it got stuck in that. Because then you had to produce documents and tons and tons of documents, and then with the translation, because something is in Persian, something is in Urdu, and so on. So I brought in this thing, and that's how the hearings began to be resumed in the Supreme Court, and we got it done quickly. So the preamble has many, many things: liberty, this, that, so on. So how you convert that into an action thing is something that we have to see. The other thing, which is also a matter of right, but it's not enforceable by me in court, but it is enforceable against the government under certain circumstances. And that's the directive principles. And the directive principles, for instance, ban on cow slaughter is in the directive principles, Article 48. So I can't go to court and say, my fundamental right is being taken away, my religious fundamental right is being taken away because cows are being slaughtered. But I can go to court and say that government must frame a law so that cows are not slaughtered. And that's part of the directive principles. And a fallout of all this is what we had later brought into the Constitution, called the duties of citizens. In that, it's again not enforceable, but it's the duty is I am duty bound to obey it, and it should be a guiding principles in say, supposing I start a school and I want to bring in some aspects of it where certain beliefs have to be taught, then that's part of the duty of the teachers to do so. So those are the parts that will take you very far afield, but on the core, you have presented everything very clearly. In short, what you said is something that should be a mantra. There is no such thing as an absolute fundamental right. There are reasonable restrictions. By the way, in the case of religion, which is Article 25, which is a fundamental right, my right to pray.
Yeah.
There are two restrictions which are extraordinary. One is you can be restricted on your rights by morality. So if I say to please Kali, I must chop the head of my son to please her, well, you can't do it because that's immoral. So on immorality, that is justified, that you can't do it. Similarly, health is another.
Yeah.
So health is something that has not been very much used, but I think we must start using it to see that people become more health conscious.
I can give you a tangible example of that, which has to do with the practice of, the Jehovah's Witnesses.
Yes, Jehovah's Witnesses.
Of which there are a few in India. Now, they're of course tiny, they are minuscule in India, but anyway, they are there. Now, they have a belief that even if a person is about to die, in other words, that their life is at risk, they should not take blood transfusion. Now, I don't know what the reason for it is, but they do. So in many countries, this has become an issue. So what happens, for example, is a child, or it doesn't have to be a child, it could even be an adult from a Jehovah's Witness family, meets with an accident. And the emergency services take the person to a hospital, and the doctors say that the person has to be given blood. There is sometimes objection by the family, saying on faith grounds we will not allow the blood transfusion to take place, even if the person dies. There can be sometimes quite hard line. And this has ultimately, of course, gone to court, these kind of cases. And the courts have had a very difficult time reconciling the position of the family and the basic humanitarian need to save a life. So there are huge problems of that kind as well. I thought I'll just sort of mention that briefly. Of course, it's a completely different case about Jehovah's Witnesses in India, which was a case that started in the Kerala High Court, went to the Supreme Court, and that gives the basic proposition that the right to freedom of expression also includes the right to remain silent.
Yeah, that's right. And the right not to vote. Yeah.
Yeah.
Well, that's very good. I mean, Jagdish, over to you.
Some of our viewers would like to send any questions, or if they have any suggestions, or you can always write to legal words of wisdom at gmail.com, where Venkat and his team will try and see if it is possible to reply to your queries. We are scrolling it, legal words of wisdom at gmail.com. So those who want to get in touch with Dr. Venkat Iyer can always send an email to Dr. Venkat Iyer, and he would try to respond to some of your questions. But please stick to the issue of legal work, because we get a lot of other requests, but it should be more to do with the subject of our program. So with this, we come to an end of another interesting fourth episode of Legal Words of Wisdom, Nyaya Gyan Ganga, which, as we know, we have it on every Saturday at 8 p.m. Indian time. Now we will be back tomorrow, that is Sunday, at 8 p.m. with our regular Sunday Words of Wisdom, Gyan Ganga. And tomorrow, Dr. Swamy and Major Gaurav Arya will be discussing a very important chapter, because the month of October is quite crucial as far as Kashmir is concerned. As you know, there were these tribal raiders who came in around the 22nd of October in 1947, and then the Maharaja of Jammu Kashmir came running to India on the 26th of October 1947, and on 27th of October 1947 he signed the accession treaty with India with Sardar Patel. So these are the important events that had happened in 1947. So we will be having a discussion known as the Kashmir, the Great Betrayal. Discussion will be between Dr. Swamy and Major Gaurav Arya. So tomorrow, watch out for this program at 8 p.m. And as usual, our legal words of wisdom, Nyaya Ganga, we will be back on next Saturday, which is the 31st of October. And Dr. Venkat Iyer and Dr. Swamy will be discussing another interesting topic on this show. We look forward for your support, and thank you for your viewership. Our last week's viewership also, we got a very good response. So with this, I thank Dr. Swamy and Dr. Venkat Iyer for their presentation and their views today. I thank Ramesh Swamy and our technical team for their support. So with this, we end today's program, and see you tomorrow at 8 p.m. for our regular show. This time it will be on Kashmir, Sunday, 8 p.m. Thank you, Dhanyavad, and Jai Hind.
Thank you.